That's going around, man.
All right. What's up? It's another episode of Operation Wise Dome. Today is Thursday, November the 20th. We is getting into something special today. We're getting into qualified immunity, the death of an illegitimate doctrine. How 150 years of judicial error built on a corrupted statute and misapplied canon are finally being exposed. This is going to be an Operation Wise Dome legal education series. It's pretty extensive in relation to the slides. I believe Tanawal Downing is supposed to be making an appearance tonight on Operation Wise Dome, so we look forward to Tanawal showing his face, maybe giving us some updates in relation to his health. But he also is very interested in this topic, as I am, because it's really changing the landscape on everything that's been happening for 150 years. So that's why I say I feel like 2026 is going to be our year. We're coming into that 150th anniversary in relation to 1776. You dig what I'm talking about? So it's just really exciting that all of these, we're getting so much momentum. We're getting JD Vance over here talking about the most sovereignest citizen. Like, what sovereign citizen? You talking about we should be a sovereign? So it's just there's a lot of things going on out here that I'm very excited for 2026. Yeah, man, it looks like we're coming in with a bang. So I'm very excited about it. A couple of things going on this week is we've had one of our peoples go to jail. We had a due process violation in relation to her situation. She immediately went to jail after sentencing, or they immediately sentenced her. Didn't give her a sentencing hearing. Sent her only for 4 days in jail. But a due process violation that just happened yesterday. Yesterday we was doing a lot of development in relation to trying to make sure that we can get her taken care of with some emergency orders. We did get another dismissal. I just posted that up on the Facebook, and people have been seeing that and responding to that in the Discord as well. Yeah, it's a small one, but it's still a dismissal regardless. We'll take any. Another win is another win. You dig? What else we got going on this week? Man, it's been crazy. Yeah, that's about it. I wanted to let everybody know. Yeah, I'm about halfway done with another book that I'm bringing in on the application of things. I've been speaking a little bit more. Again, we are looking at doing another event towards the end of April, maybe May of next year. This is going to be an all-inclusive event though, so it's going to be a little bit more expensive. But it's 5 days all inclusive, food, lodging, the whole 9 yards. Every day is going to be planned out from early morning all the way to late is going to be lit. It's going to be real fun. You might even find love. I know we have someone recently, a couple recently might be finding love, right? So it's pretty cool. But yeah, this is just amazing to see, and I'm so proud of everything that we're doing. So let's get into this bad boy. Any comments? Anything? Anybody want to say anything right now? No, y'all being quiet on me. I don't like it when y'all don't talk to me. Y'all just make me be the guy that talk the whole time. Like, what? I hate it. I don't like it. But whatever. I'll just let y'all slide right
I'm
now.
tired.
Nah, man. Life too short to be tired. Better stay awake.
I
All right,
got a quick question on qualified immunity.
all
If
right, let's do it.
if a deputy comes out and says what you're doing doesn't seem to be breaking the law, and I continue to do what I do for several years, and another deputy comes out and says basically jumps up and down but doesn't cite me and leaves, and another deputy comes back a year later and gives me a ticket. And then I say, well, what's going on? For years, I was operating under the
Presumption.
presumption of lawfulness, and then they do this, and if they sustain it, or it's deemed lawful or unlawful, or how can, if it's deemed lawful and they kept coming out and bugging me over it, is there any kind of loss of qualified immunity because the first guy came out and said, oh, no harm, no foul, so the next
I
guy
mean,
should?
we would definitely have to get deep into it, but I would think that again, like we know, officers of the law or those who are engaging in the process of the law must know the law, and if they make any mistake in the law or the process of its application, they must respond in damages. So we know that to be a fact. I think we would just have to look a little bit deeper. I think it could be applied. Of course, they're going to use qualified immunity right off the bat, but I think I wouldn't say utilizing what the other cop said would be beneficial. I would just say that he's already supposed to know. And if he doesn't do proper investigation in relation to that statute and its application, the elements that must be met, which they do it all the time. Like if I just look at a recent situation that I had, right? So let's take this off just 1 second. So I had gotten a ticket from a Yakima police officer like a month and a half ago, right? And this dude initially was trying to give me a driving while license suspended. I'm gonna make a quick request. If you can turn on your camera tonight while I'm doing all this, that would be great, because I want to speak to you. I want to look you in your eye. I want to see your reactions. I don't want to talk to myself. I'm gonna actually turn off my camera on y'all if y'all don't turn on your camera, right? And I'm not gonna be as good because I don't have a beautiful face to look at, right? I don't get to see the perspective of me. You know what I'm saying? Like all of y'all is me. You know what I'm talking about? So, yeah.
Gotcha.
And I'm you dig? Now, so what I was gonna say though is that this cop, he gave me a driving while license suspended. And I look at him, I said, "What you give me tickets for?" He said, "Driving while license suspended." I said, "Nope, you can't do that. I'm telling you right now, I ain't got no license. You better look in the system." Right? So he goes and he looks into the system, and he verifies that I have no driver's license, right? And I'm about to show y'all real quick. And I think this will be beneficial. I think this will be beneficial for people in the future. Let me see. I got to find the email real quick. Hold on. I think this will be beneficial for people in the future to do and to have, okay? Because they're always going to try and pull this bullshit on your ass, and you want to be prepared as possible, okay? So this is part of my discovery from my Yakima case, right? And quick update. The joint injunction has been signed. I don't know if y'all know this or not, but the joint injunction has been signed completely. Yeah, me and Leah signed that bitch, so we're good to go. You know what I'm saying? The joint injunction has been signed. Yeah, you dig what I'm talking about? So we're good to go all the way, bro. That bitch got signed yesterday. You hear me, cuz? So we good to go. You know what I'm talking about? Yeah. So yeah, we got that injunction signed. I ain't filed it yet, but it's signed, baby. You know what I'm saying? So I'm really stoked about that, bro. Okay. Here I wanted to show y'all with this. So the cop ends up changing. The first Yakima cop ends up changing it over to driving without a license, because I don't have a license. Okay, that's the proper statute to apply. Okay, if you want to apply one, okay, on your presumption. The second officer over in Union Gap, the next city over, they really all like one. This dude, he goes and gives me a driving while license suspended. Okay, and I even told him, and he said, "Oh, it's suspended." Okay, so this is what they see when they actually. I called the Department of Licensing yesterday, and I spoke with him. Okay, and I didn't get it recorded, but this is an identification number that they give me, right? It's not a license number, it's an identifying number. Because what you'll notice is that over here it says license issued and license expires. There are no dates because there was never an issuance of a license, okay? Now you can get this same type of report by contacting your Department of Licensing, okay? And if you keep this with you, maybe you get it every 6 months if you want. Hey, need an updated licensing report, okay, in relation to me, right? And keep a couple of them, keep them coming, and always keep them in your car. Why? Because you're not supposed to get arrested on not having a driver's license. Driving while license suspended, it can be, but driving without a license at all, or traveling, excuse me, no. After a diligent search, the personal driver license suspended or revoked. Now what has been suspended is what I asked DOL yesterday. Well, what's been suspended is your right to apply for the privilege. Thank you. Appreciate that clarification. Commercial, not licensed, not eligible. Here we go with some statements though. No valid personal driver's license. Had not been issued a valid Washington license. I've never applied. Never applied. Every time they've sent over one of these even letters, they to the wrong motherfucking address, bro. They to the wrong address. I don't live there, bro. I don't live there. So if you keep this, look, custodian of records, signature and all, bro. So if if you keep it something, they trying to give you a driving license, no, sir. Right here, you can look in the Department of Licensing. I have the report as well that I don't have a license. Never applied for one. So you're gonna have to write me up for the right statute. That way, you're getting yourself, because what ends up happening is it goes from literally, bro. If you get a ticket for oh my God, driving. If you get a ticket for driving while license suspended, it turns it into a criminal act. It goes from the infraction up to a misdemeanor. You see what I'm saying? So you got to go to the county courts. If they keep it as not having a driver's license, didn't present a driver's license or don't have one, it stays in the infraction zone. How do I know? Because I just had a Yakima write me up a whole bunch of tickets and I didn't go. And what did they do? They found me guilty and sent me the fines. And guess what? Now a collection agency is trying to contact me to pay those fines because I don't have a driver's license. But when they move it up into an illegitimate charge, which I've already, I believe, hit for to the prosecutor, because they got a warrant out for me on this one already. Let me see. The court notified me on my hearing that I went to. Let me see. What is it? What am I looking for? Overleaf. Sorry, I'm trying to get into qualified immunity. I just want to get through this real quick. Okay, so y'all been working.
Yeah. Now, quick question for you. While you stated it's a bench warrant, correct?
Yeah.
Okay. How would you quash that?
You send in a quash?
Okay. Let's say they deny.
Well, why would? Well, if you put in really good reasoning, they probably wouldn't deny. But if they denied, you might have to just go ahead and post like a little bond.
Like a ROR?
Well, you can post a bond, and then if you do it directly, because they're not going to make it super big like with mine, they're not making it really big either. And then you get all that back no matter what happens, whether you get found guilty in appeal or not, you still get the bond back. Okay. So what I ended up doing is I went ahead and instead of doing a motion to quash immediately or right off the bat, I hit for a prosecutorial notice and demand for an immediate entry of nolo prosecute. And the reason is because the statute doesn't fit. Okay. I also attached the exhibit of this Department of Licensing. No valid PDL. Okay. Then I also showed or also attached the ticket that was given to me earlier in the year from the first officer that shows that this is the correct statute to be applied. I don't have a driver's license. Y'all hitting me for driving while license suspended is not true because I don't have a license. My privilege has been suspended to apply if y'all want to do that. But other than that, it cannot apply. So I'm hitting the prosecutor first, right? And let them know. They got 10 days to respond to me. If not, I'm going to hit for a motion to quash and then a motion to dismiss with prejudice because, again, applying the rule of lenity will not allow the statute to fit because they don't have a driver's license. One has to have a driver's license to have a driving while license suspended. Period. That's how it works. All right, so we're going to stop on that. I just wanted to show y'all that real quick and update y'all. If y'all want to get something in the DOL that's showing your status that you don't have one, do it. That's going to bring it forward. You're going to be sitting all right. You dig what I'm talking about?
Hey, Cam.
Yeah.
What if you've already gotten a driver's license and you want to revoke it yourself? How does that work in your same scenario?
Okay, so what state are you in?
Me, I'm in Missouri.
Okay, so Missouri, you would do. Okay, so they're saying in their DMV. Ooh, I know I found this Missouri one. Ooh, it was under a weird one. I'm gonna actually have to look because I do remember now with Missouri, they had that bitch hidden and we found it. I found it, but I'm gonna have to. Find it again. I remember Missouri being hard. Be prepared to complete it depending on the surrender. You need to fill out an application. When is the application for? Yeah, I'm gonna have to find it. But normally in all states, they have a DMV surrender form. And if I'm not mistaken, it was Missouri that was hard to find for a second, but we ended up finding it. And yeah, because Google's just saying the same thing. This is the surrender form for Texas. You just surrender it. You use their form. All I gotta do is look through the Discord and I'll find it because everybody's channel has their state that they're in. So I'll just look through my Missouris and I'll find it. If you could email me though, cam@piitp.com. That way I'll remember, and then I'll make sure to go look for it and then send it to you as well. Okay?
Yep, you got it.
You gotta remind me though, Papa. All right, let me see. I'm gonna get y'all back on screen. So I'm watching y'all. Oh, y'all didn't see it. Oh yeah, I am sharing my screen. I'm sharing my screen. Y'all can see that?
Yep.
Okay.
Yeah, we see it.
Yep.
Okay. I just want to make sure. Yeah, this is a surrender form, and that their form here in Texas would be DL-174. That's the form number. All right, let's get into it. I don't need this.
I should sign it with qualified signature.
All right. Again, qualified immunity, the death of an illegitimate doctrine. Can judges create law that Congress never authorized to shield government officials who violate your constitutional rights? For over 50 years, the answer has been yes. Government officials have enjoyed qualified immunity, a judicially created doctrine that bars civil rights lawsuits unless specific constitutional... Oh, God, no. Unless the specific constitutional violations was clearly established by prior case law with nearly identical facts, which has been real shitty. I mean, there was a situation where one opinion was, well, there's not clearly established law that police officers can't take anything or steal anything from the house when going in to do an investigation, so therefore qualified immunity has been granted. It's like, bro, yeah, that's a real thing. That really happened. That really happened.
There was one where they can't, it's okay to murder somebody. That it wasn't clearly established that you can't murder somebody.
Yeah, like they be out here wilding, bro. Okay, this doctrine was invented by the Supreme Court in 1967. Purportedly based on the common law principles and statutory interpretation. However, recent scholarship has revealed that the qualified immunity rests upon two catastrophic errors. First, the misapplication of canon or statutory construction that was never used for defenses. Very important. Very important. And second, the Supreme Court's reliance upon a corrupted version of 42 U.S.C. Section 1983 or Ku Klux Klan Act that was missing critical text explicitly displacing state law immunities. Explicitly displacing state law immunities. So tonight we're going to examine these errors, how these errors are being exposed by the scholars, acknowledged by federal judges now across the ideological spectrum, and why the doctrine days are numbered. Okay? Tonight's journey through the constitutional era and judicial reckoning are going to be the historical foundations, understanding the Ku Klux Klan Act of 1871, the Reconstruction era of civil rights protections, and congressional intent to prevent the state law from blocking federal remedies for constitutional violations. We're going to be looking into the lost text discovery, Professor Alexander Reinhardt's groundbreaking research revealing the notwithstanding clause, which was completely deleted from Section 1983 in 1874, and its devastating implications for qualified immunity's legitimacy. Then we're going to be looking at the judicial reckoning. Of course, Judge Carlton Reeves is my favorite in relation to this, in the historic order in Green versus Thomas, cross-ideological judicial consensus and federal judges signaling to the Supreme Court, the practical application on how to challenge qualified immunity in current litigation, preservation of issues, the birth of qualified immunity, examining Pearson versus Ray in 1967 and the derogation canon misapplication, and how the Supreme Court created a defense Congress never authorized. Ooh, I'm going to make this y'all bigger so I can look at y'all. Let's see, bring this up.
It was never intended for an offense. It was intended for a defense.
Yeah. That's what I'm saying. Like, they totally screwed everyone, bro. Excuse me. Get rid of this. I'm way better than Saturday, that's for sure. And then the doctrine's absurd results, right? Case studies demonstrating how clearly established law has become a trap, preventing accountability for egregious constitutional violations that no one in the, it's so elementary, it needs no explanation. And then natural law and the path forward, integrating creator endowed rights frameworks, state level reforms, and strategic implications for civil rights litigation. Okay. The creator endowed rights framework. So natural law foundations precede and supersede positive law constructions. Of course, we know this, but quote, We hold these truths to be self-evident, that all men are created equal and that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The staple of everything, the foundation of all. Nothing can supersede. Nothing. Oh, sorry. Before examining the qualified immunity's technical defects, again, we must establish the philosophical framework that exposes its fundamental illegitimacy. The Declaration of Independence articulates the foundational principle of American jurisprudence. These rights are not granted by the government. They pre-exist governmental authority and constrain its exercise. Natural law. The law written upon the human heart and discernible through reason establishes that individuals possess inherent sovereignty and that governmental power is limited and derivative. When judges create doctrines like qualified immunity that render constitutional rights unenforceable, they engage in positive lawmaking that contradicts the law, natural law principles. A right that cannot be vindicated is no right at all. Am I right or wrong?
Right.
It is merely a suggestion, subject to governmental whim. This course proceeds from a premise that individual sovereignty, limited government authority, and accountability for those who violate creator-endowed rights are non-negotiable principles against which all legal doctrines must be measured. So qualified immunity allows government officials to violate constitutional rights without consequence, transforming these sacred guarantees into empty promises. This inversion, where governmental power supersedes individual rights, contradicts the very foundation upon the American Republic and how it was established. The Reconstruction and Reign of Terror is the historical context that necessitated federal rights legislation. So following the Confederate surrender in 1865, the promise of freedom for 4 million formerly enslaved, I want to say black Americans, I'd like to say the true Native Americans, but we're going to not go so far right now, confronted a brutal reality that white supremacist terrorism designed to maintain racial subjugation through violence. Organizations such as the Ku Klux Klan, the Knights of the White Camellia, and the White League unleashed systematic campaigns of beatings, lynchings, torture, mutilation, and murder across the former Confederacy. These atrocities were not random acts of lawlessness, but calculated political violence aimed at preventing, I don't even like to say black, swarthy political participation, economic independence, and social equality. The violence was inflicted with complete impunity because state and local governments were either complicit or controlled by the very individuals perpetuating the terror. Judges refused to prosecute, sheriffs refused to arrest, and juries refused to convict white supremacists who murdered black citizens. I hate saying black, bro. The 13th, 14th, and the 15th Amendments had abolished slavery, guaranteed equal protection and due process, and protected voting rights. But these constitutional guarantees meant nothing without enforcement mechanisms when state governments refused to act. So the federal intervention became not merely advisable, but absolutely necessary to vindicate the constitutional rights that Reconstruction amendments had promised, but state governments systematically denied. Any comments so far?
Like what Dr. Martin Luther King said, do not judge a man by the color of his skin, but the color of his character.
Oof, tough, straight up. So the congressional response. This is where we had the creation of the Ku Klux Klan Act of 1871, the federal intervention to protect constitutional rights when the states had refused. Faced with the systematic state failures to protect constitutional rights, the Reconstruction Congress enacted the Ku Klux Klan Act of 1871, also known as the Civil Rights Act of 1871. They didn't like that Ku Klux Klan Act, so they tried to change it up to the Civil Rights Act of 1871, which then also translated into this landmark legislation codified at 42 U.S.C. Section 1983. Okay. Created a federal cause of action, allowing individuals to sue state and local officials who violated their constitutional rights while acting, again, quote, under color of law. Can someone explain to me what color of law is, please, in greater detail? Please.
It has the name and form of law, but not actual law. Like RCW, Revised Code of Washington. Mm-hmm. How is code law?
How is
code? Code is code, law is law.
Thank you.
Null and void.
What else? Anybody else? So what would that make? Not just codes, but what else?
Law of contracts.
statute, ordinance, public policy.
They have the appearance of a law. They have they have the appearance of a law. The appearance. That's it. It's not true law though. So whenever all your friends, maybe not y'all's friends, because y'all are smart people and you hang around people that aren't so, mainstream. I know you know. But for the normies out there, okay, they believe that a statute, code, and ordinance is law. Not today, buddy. Not after this one. The statute's purpose, the statute's purpose was revolutionary. To, quote, interpose the federal courts between the states and the people as guardians of the people's rights, unquote. Excuse me. This is coming out of Mitchum versus Foster, 407 U.S. 225, 242 in 1972. So Congress fundamentally distrusted Southern state governments to enforce the newly enacted constitutional amendments protecting Black Americans. The Ku Klux Klan Act represented a dramatic expansion of federal judicial power into areas traditionally reserved to states, reflecting Congress's determination that federal remedies were essential when state remedies were unavailable or inadequate. The state's plain language. The statute imposed liability upon any person who, acting under color of state law, deprived another of constitutional rights, with no mention of defenses, immunities, or exceptions. Okay, exceptions is a big word. So is exemptions. You are exempt actually from a lot of things. You got to find the exemption though. Key provisions. Any person. Broad liability for all state actors. No exemptions for official status. Quote, under color of state law, unquote. Covers actions taken with authority derived from state law even if unauthorized. Shall be liable. Mandatory liability. It's not discretionary, homeboy. No defenses mentioned. Congress was silent on immunities because it intended none. If you fuck up, you fuck up. You gonna pay. The statute's text was unambiguous. Unambiguous. The original text of section 1983, what Congress actually enacted in 1871 versus what courts have interpreted. The Civil Rights Act of 1871, Section 1, now 42 U.S.C. Section 1983, originally provided that any person who under the color of law, statute, ordinance, regulation, custom, or usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall any such law, statute, ordinance, regulation, custom, or usage of state to the contrary notwithstanding be liable to the party injured in any action at law, suit in equity, or other proper proceeding for redress. The emphasized language, the notwithstanding clause. Big one. Because right now what's going on in Hood River, they trying to hit for qualified immunity. We coming. I'm coming with another sir reply on they bitch ass real quick. Okay? Is the most powerful override language available in legislative drafting. Notwithstanding is the highest bar in legalese. Highest. Means despite, regardless of, or in spite of. It is an explicit instruction that the liability created by the statute applies regardless of any contrary state law. Any. This includes a state statutory law, state constitutional law, state regulatory law, state customs, state usage, and critically, state common law. Since immunity defenses for governmental officials, to the extent they existed in 1871, were matters of state common law, the notwithstanding clause explicitly displaced those immunities for actions brought under the federal civil rights statute. I don't know why I'm getting cut off, bro.
I hear you fine.
No, my slide is cut off, bro.
Oh.
Okay, I don't know why when I go full screen it's doing it though. That don't make no sense to me. Like when I go full screen.
I was just going over this in the Discord that all states have subjected themselves to federal law in every single constitution.
I don't know why it's doing that. Yeah, that sucks.
I think it was Article 30 in the Washington State Constitution recognizes the federal constitution as supreme law of the land.
And I'll just do it like this. Fuck it.
Y'all hear me?
Yeah, we can hear your low ass voice.
Yeah, sorry. I hate to point it out, but isn't it the Ku Klux Klan, not the Ku Klux? Just wanted to.
Oh, it's all good, bro. Don't worry about no spelling errors. We know what it means.
Oh,
All right. So, yeah, who cares? All right. So,
Yeah.
where's we at?
just making sure I'm not crazy.
Was we on 7? Contrary to any state law or state statute. My bad. I'm not perfect. All right. So the 1874 deletion and the 150 years of error. Okay. So in 1871, Congress enacts Civil Rights Act. I'll go full screen and then we'll come back down just so I can make sure not to miss anything. Congress enacts Civil Rights Act. The original statute includes the notwithstanding clause, okay, explicitly displacing state law immunities. Explicitly, like it's there. You can't combat it. Then in 1874, the reviser or the compiler, okay, putting everything into federal codification of statutes, omits. He just straight up omits the notwithstanding clause during compilation without congressional authorization at all. 150 years of error perpetuated. Corrupted version carried forward into U.S. code. Every qualified immunity case based on missing text, bro. Think about all these people that are still alive today. If they know this now, how big of a check they can actually, you know what I'm saying? Because now they got the eligibility to attack not only the government, but also, also the judges personally, because they should have known. Again, they're supposed to know the process. Okay, let's check this out real quick. One backup. I can get a quick backup. Just a quick backup. For anybody new, for anybody who hasn't seen it, just a quick little backup. Maybe in yellow. There she goes. Bring it bigger and then zoom in. Oh shit, way too big, bro. Chill. All right. Quote, the officers of the law in the execution of process are required to know the requirements of the law. The officers of the law. What does that include? Does that not include judges? Are required to know the requirements of the law. And if they mistake them, you hear me, Bob? And if they mistake them, whether through ignorance or design, sorry, it's not my fault, and anyone is harmed by their error, they must respond in damages. Okay? They must respond in damages. That includes judges, bro. All right? So,
isn't judges executive?
Bro, they're officers of the law, are they not?
Yeah, executive officers.
That's fine.
No?
You can put whatever title you want to in front of it. They're an officer.
Yeah.
The reviser's limited authority. In 1874, Congress undertook the first comprehensive compilation of all federal statutes into a single, organized code. Congress appointed a reviser to compile and organize federal statutes, but explicitly limited the reviser's authority to organizational and stylistic changes. The reviser was forbidden from making substantive alterations to the law. Despite this limitation, this fucker, okay? Oh, God. And I wish we knew his name so we could put his ass on blast. You dig what I'm talking about? Compile this when the reviser compiled, despite this limitation, when the reviser bro, you're just supposed to scroll down. Okay. Compiled the Civil Rights Act of 1871 into the revised statutes of 1874, the notwithstanding clause was omitted entirely. No explanation was provided. No congressional debate occurred. The amendment was enacted. The devastating consequences. A critical sentence, one that explicitly addressed the precise question of whether state law defenses applied to the new federal cause of action, simply disappeared. This deletion was carried forward into the United States Code and has remained absent for 150 years. So every qualified immunity case decided by the Supreme Court, every circuit court, every district court has been based upon a corrupted version of the statute that was missing the text Congress actually enacted. Do you see how huge this is? It's kind of like Chevron doctrine and how huge that is. The implications of what that has changed. Okay. So Pearson versus Ray in 1967, the foundational case. How the Supreme Court invented a defense Congress never created. The facts. Pearson versus Ray involved Mississippi police officers who arrested 15 Episcopal clergymen, both black and white, for attempting to use segregated bus terminal waiting room in 1961. The clergymen were convicted of a breach of the peace under the Mississippi statute that was clearly unconstitutional. They sued the officers under Section 1983 for the false arrest and imprisonment. The Supreme Court faced a straightforward question. Does Section 1983 permit damages claims against police officers who violated constitutional rights? The statute's text provided a clear answer. Yes. Yes. Any person acting under color of state law who deprives another of constitutional rights shall be liable. The statute contained no exemptions, no immunities, no defenses. The court's holding. Nevertheless, the court held that Section 1983 incorporated a good faith immunity defense that had existed at common law. The court's reasoning rested upon two pillars. First, the statute's silence regarding defenses should be interpreted as preserving common law immunities. Application of derogation canon. See that? The application of a canon. Which canon? The derogation canon. Okay, so when everybody be thinking, oh, canons can't be used, maxims can't be used, doctrines can't be used, bullshit. Bull fucking shit, bro. Second, Congress would have explicitly stated if it intended to abolish such immunities. Never did. Both pillars, as we shall see, were fundamentally flawed. The court engaged in judicial activism at the highest order. Illegal, using dubious and misapplied canon to create a defense that Congress not only failed to enact, but explicitly fucking rejected through the notwithstanding clause. Literally rejected it. So, the derogation canon explained. Y'all liking this so far? Is this working out good for y'all tonight? Y'all liking this?
Yeah, it's awesome shit.
Yeah.
Yeah, it's cool, man.
Fucking get it, you did.
Arsenal for the weapon.
Yeah, let's fucking go. So the derogation canon explained. Oh, you wanna know what? I wanted to give a quick shout out if I can. I'm gonna take it off screen share just so you, because I want to show y'all something. I don't know if y'all have seen this or not, but we got a big shout out recently, and I just wanted to make sure that all of you know this. If you don't know this right now, we got a really big shout out, and this is kind of huge for not just myself, but I feel like all of us, because I am you and we are us and we are all a part of the great I am, right? But I think it's huge, and I just kind of wanted to show y'all.
Cameron Wilson's page.
It's not my page.
The videos that get by far the most are the window breaks, and there's hundreds of thousands of views, and it's insane. So there's a lot behind all of that, and it's just a big ball of chaos. But like, I don't teach that. I don't recommend that. I still recommend Cameron's group though, because even though there's a lot of that, and it's still, I look past that because the amount of awesome stuff they're doing, and they're trying all these different things, and they have videos, and they're critiquing the videos. They're meeting twice a week. Like as long as they continue to learn, and as long as they continue to look at everything with a critical eye, there is no other group on the fucking planet doing anything like that anywhere. And until there is, I have to recommend Cameron Wilson, even though Cameron Wilson.
Okay, operate fucking weird wise dome, the greatest on the fucking planet, nigga. Let's go. What y'all talking about, man?
Yeah.
Gotta qualify with a notwithstanding.
Fucking talking about, man. Fucking great on
Notwithstanding
the planet coming out of Brandon's mouth, bro.
No. It's the best one around. Cameron Wilson, best one around, notwithstanding anything.
You dig what I'm talking about? Everybody, y'all just shout out to Brandon. Y'all unmute and say, appreciate you, Brandon. Thank you, Brandon. I'm
Brandon, I love Pickletaria.
Everybody,
Pickletaria.
Thanks, Brandon.
Show some love.
Appreciate you, Brandon.
Yeah, show him some love, man. All right. So let's get back into it. I just wanted to give y'all a little bit of encouragement that came out of the King of Pickletary's mouth himself. Wisdom is the greatest group on the planet. And he knows a lot of people. Y'all know he knows a lot of people. Y'all quit playing with me, man. This is really cool. Hey, man.
Well, from the first Wise Stone member, it is the best one around.
You did? He was a ball. Okay. So the derogation canon explained. The derogation canon is a rule of statutory construction providing that statutes, quote, in derogation of common law, unquote, shouldn't be strictly construed. Strictly. Man, this is great, right? You better look for them canons. These are good ones. Meaning courts should not assume that legislatures intended to displace common law rules unless the statute explicitly says so. This is a huge canon, y'all. If you apply this in any of your notice and demands and anything that you're bringing forward, it's huge. This is a great, great canon to use.
I'd like to point out something, if I may. In Kentucky, they have a blanket one that abolishes common law.
Ooh.
So then check that out for your state.
That is very interesting. That would be a constitutional challenge that I would bring forth in a judicial notice. Good looking, bro. Good looking.
They can't.
They can't. No, they can't. He's just stating that, again, you got to remember that we just spoke on this in the last slide where it states that it doesn't matter even if it's a state constitution. Right? Even if the state constitution goes against it, it's not applicable. Okay. So how the canon operates. When a statute appears to alter or eliminate a common law rule, okay, courts applying the derogation canon. You know what? I need to make sure that I'm giving Tanawa the link for tonight. Sorry. Give me 1 second. Paste. There we go. Okay.
Aw, shit. Hell yeah.
Yeah, he's supposed to be making an appearance tonight. We was texting earlier.
I was spitting some 10-0 on the Discord.
Okay, you already know. Yeah, I be texting my boy. All right, so when a statute appears to alter or eliminate a common law rule, courts applying the derogation canon will interpret the statute narrowly to minimize its impact on the common law. Think about operating and bringing in also the rule of lenity. So you got derogation canon and the rule of lenity being brought forth together all in one. That's I would say that's pretty damn powerful, bro, if you ask me. The underlying assumption is that the common law represents a perfected system of justice, and statutory departures from it should be limited. This canon originated in an era when English courts viewed the common law as a perfected system of justice developed through judicial wisdom over centuries. While parliamentary statutes were viewed in suspicion of political interventions that might disrupt the common law's coherence. The canon reflected judicial supremacist notions. The idea that judge-made law was superior to legislative enacted law. Okay? The canon reflected, I gotta repeat this, judicial supremacist notions. The idea that judge-made law was superior to legislatively enacted law. A controversial doctrine. In the American context, the canon was imported from English jurisprudence, which can also go into the Anglo aspect, but has been controversial since the early 20th century. And if you don't know about your Anglo history, you might want to go figure that out a little bit more on Curamayo's channel. All you got to type in is Anglo. Hey, man, we talking about, what is a real Anglo? Okay? Boy, you better get some real history about that. Your history that is not what's up. So, Rosk has been controversial.
Well, in the context of judicial prudence, it goes back to the Magna Carta, doesn't it?
It would go back way before. So Roscoe Pound, writing in 1908, condemned the canon's, quote, archaic notions of interpretation as, quote, wholly inapplicable and out of place in American law today. The canon's fundamental premise that common law should be privileged over statutory law contradicts basic principles of democratic governance and legislative supremacy in a self-republic system. In a democracy, the people's elected representative in legislation. Oh shit again. Oh, it's not. Okay. Where was that at? In a democracy, the people's elected representatives in the legislature have the primary authority to make law. When courts use the derogation canon to limit statutory language, they elevate unelected judicial precedent above the will of the democratic branches, a deeply problematic inversion of constitutional authority. Can I full screen this one? Probably so, without cutting anything off. Cool. All right. So the derogation canon's proper application, rights, not defenses. How courts actually used the canon for centuries. Professor Reinhardt's exhaustive research. Professor conducted an exhaustive historical research, examining every Supreme Court decision from 1798 through 1871. It's pretty crazy. It's a lot of research. It's kind of like me before I got into doing this full time. I would just do the fucking research, forever. His findings was unequivocal. The canon was used exclusively to protect common law rights and claims, never common law defenses or immunities. When courts applied the derogation canon, they were protecting individuals' pre-existing entitlements, such as property rights, contract rights, tort claims, and liberty interests from being eroded by statutory enactments. That's exactly what Bob was talking about earlier. When courts applied the derogation canon, they were protecting individuals' pre-existing entitlements. The canon operated as a shield for individual rights against governmental power, not as a shield for governmental power against your individual rights, bro. That's not how this works, bro. That's not how this works.
If I may?
Go ahead, please.
Government is set up to protect and maintain each individual rights. So the court's jurisdiction is limited to protecting and maintaining each individual right.
Boom. Bing, bong, boom, bop, ping, pop, bam. The jam. It's kind of like the same argument we had in relation to Hayden, right? Again, the cop in relation to a traffic stop is supposed to be only when there's a safety risk posed to another. Only when. Again, let's continue. What the canon protected versus what it did not protect. It protected individual rights, common law property rights, contract rights and obligations, tort claims for injuries, liberty interests and personal autonomy, individual remedies and causes of action. But it never protected government defenses, common law immunity defenses, governmental privileges or exemptions, official immunity from liability. It's not what it was. Applying the derogation canon to preserve governmental immunity defenses inverts the canon's historical function. They literally flipped it on its fucking head, bro. The same way that they flipped sovereign citizen on its head. That's what they do with so many things in this life. They just take decades. It takes a couple decades, but they slowly wean it into the education system. And then what happens? Here we are now in 2025 talking about a sovereign citizen as part of a terroristic group. When back in 1940, we ain't even talking 100 years ago now. When back in 1940, it was the highest status that one could have in our self-governing republic. Completely flipped. So applying the derogation canon to preserve governmental immunity defenses inverts the canon's historical function. It transforms a principle designed to protect individuals from government into a principle that protects government from individuals. Like, they literally flipped it from protecting us from the government to now. You see what I'm saying? Us good. The complete reversal of the... Dude, it's all about education, right? It's all about wisdom, right? It's all it's based on. A complete reversal of the canon's purpose and historical application. It's so sad. So, I'm going to have to back out of this when we get to the bottom. All right, so the Supreme Court's unprecedented inversion. Pearson's application had no historical precedent. So when the Supreme Court in Pearson versus Ray applied the derogation canon to import common law immunity defenses into Section 1983, it did something unprecedented in American jurisprudence. Never before had the canon been used to dilute a newly created statutory right by implying a common law defense. Never. Pretty wild, right? It never before had the canon been applied to defenses or immunities, only to rights and claims. Never before had the canon been used to protect government from individuals, rather than individuals from government. So Pearson's reasoning failed on multiple levels. The first failure is the historical application, right? What is a doctrine or an act that we utilize in relation to historical application? Come on now. I'm not moving forward till somebody give me the answer. That means y'all ain't fucking learning. If we're taking back a statute all the way back to its original intent,
Rule.
Yeah.
About to say, you better not be failing me if we're the greatest fucking group in the goddamn planet. Come on, Wise Domians.
I got stumped for a minute, man.
Yeah, let's get this shit. Wise
Statutory courts are inferior to common law rights.
Correct. Right? So, the historical application is Reinhardt's research shows the canon had never been applied to defenses, making the court's use historically unprecedented and unsound. Okay? Second failure is the remedial statute principle. The canon conflicts with the principle that remedial statutes should be construed broadly. Section 1983 created new rights where none existed. The third failure is that the canon was unnecessary. The canon was unnecessary. The statute's original text explicitly addressed state law defenses via the notwithstanding clause. Congress did not leave this to inference. The fourth failure was judicial activism. The court used a misapplied canon to create a defense that Congress explicitly rejected via the notwithstanding clause. Okay? Scroll down. So the Supreme Court's application of the derogation canon in Pearson represents judicial activism. You see how now we're going to beat this motherfucking qualified immunity when it comes up? Using, wait a second. Wait a fucking second. Wait a second. Matthew. Hey.
Matthew's outside.
Hey, wait a second. Are you about to make an announcement to the Wise Domians on Yeah, y'all are on camera. I just seen it. Do y'all want to make the announcement?
I'm not on.
Huh? Do y'all want to make the announcement?
Do it.
Do you want to make the announcement? The big news?
You want to do it? Is he talking to us?
What's up? What's the announcement?
You know what it is. I just seen it. She was just washing dishes. Can you make the announcement? You want to do it? Right here on Wise Dome.
Yeah, hot off the press.
Hot off the press. Let's do it. You want to do it or no?
I'm scared because of my Butler County case.
Why? That has nothing to do
They're
with
trying
it.
to put me in jail for a year.
That's not going to happen. Calm down.
Do that while I'm
Get out of there. Do you want to make the announcement now or no? Tell me.
No, not right now.
Okay, we'll do it later. Congratulations, by the way.
Thanks.
You're welcome. Oh, y'all are my favorite. I can't wait. Y'all need to let me know, bro. I'm coming. I'm coming when it happens. Okay, y'all let me know. I'm coming. I'm bringing gifts and all.
Okay, sounds good. We'll let you
I
know.
I want to be at the shower. Okay. All right. Yes. Okay. So the Supreme Court's application of the derogation canon in Pearson represents judicial activism, using an interpretive principle in a way it had never been used to create defense contradicting the statute's explicit text and congressional intent. Okay, let's move forward to the next slide. Okay. So the Supreme Court's unprecedented inversion. Oh, we just did that one. Sorry. Next one. So Tenney versus Brandhove. This is in 1950. Oh, am I sharing screen? Oh, yeah.
Yeah, you're good.
Okay. 1951. The precursor, excuse me, absolute legislative immunity and the seeds of qualified immunity. Absolute legislative immunity. Before Pearson, the Supreme Court addressed immunity defenses in Tenney versus Brandhove in 1951, which concerned whether Section 1983 permitted damages claims against state legislators. The court held that legislators enjoyed absolute immunity from damages for their legislative acts, based on the long historical tradition of legislative immunity in English and American law. The court reasoned that legislative immunity was essential to the separation of powers and functioning of representative democracy. Legislators must be free to debate, deliberate, and to vote without fear of civil liability for their official acts. Tenney's reasoning, while questionable, at least involved a specific category of officials or legislators with unique constitutional status and historical immunity traditions. Oh my God, I'm out of a drink. I'm gonna go get something to drink. Hold on. Oh, yeah, Sarah, come on in, girl. Okay. Immunity traditions. Okay. Planting the seeds. So critically, in Tenney Court suggested that while legislators might enjoy absolute immunity, quote, an official acting on behalf of legislature, unquote, might not, implying a distinction between legislators and executive officials. Pearson extended the immunity principles far beyond this context, applying them to ordinary police officers with no comparable historical immunity tradition whatsoever. At all. Moreover, Tenney was decided before Professor Reinhardt's discovery of the notwithstanding clause. So the court was unaware, of course, that the statute's original text explicitly displayed state law immunities. They weren't looking for it. They were going straight to the codification. Tenney established the problematic precedent that Section 1983's silence regarding immunities could be interpreted as preserving them, a premise that contradicts we're on 13 or 14. That contradicts the statute's actual text with the notwithstanding clause. Okay, I can't see nobody's face. Oh, okay, that's how y'all gonna do me? All right. I guess I ain't talking to nobody today, huh? All right. That's how y'all gonna do me, huh? Okay. I mean, somebody. I better see somebody's face. I feel like I ain't talking to nobody.
That light's dark.
Wow, really?
Yeah, bro. I don't want to sit up here with like looking at myself.
Here I am. I'm getting dinner, man.
I'm here.
Mind me. I'll be back on.
All right. Everybody disappeared for a second. I was like, man, come on, bro. Y'all quit doing me like that.
So you're gonna make this presentation in court, or is that how you're gonna end qualified immunity?
We develop. You got to book me, bro, if you want to get a development to be qualified immunity. So, from good faith to qualified immunity. Pearson versus error. Well, everybody's situation is different, right? So I can't just give you some kind of template. That's the old school guru way of doing things. Give you a template and hope you fucking get it. That's not what we do here in Operation Wise Dome. We go deep. So Pearson versus error, and we make it very precise. Pearson error. So from 1967 to 1982, there was a subjective good faith test. Pearson versus Ray in 1967 created a good faith immunity defense based on the officer's actual subjective belief in the lawfulness of their conduct. The test. Did the officer actually believe their conduct was lawful? This required inquiry into the officer's mental state and subjective intent. The common law connection. This test had some connection to common law or good faith defenses that existed in certain tort contexts through its application of constitutional violations, though its application to constitutional violations was unprecedented. I'm so tired of being sick. And that common law connection. This test had some connection to common law, good faith, that defenses that existed in certain tort contexts through its application to constitutional violations was unprecedented. The problem: subjective inquiries were difficult, time-consuming, and often required trials to determine the officer's actual mental state. Now, let's move over into the Harlow error, okay? This is from 1982 to our present day, okay? And it's objective, clearly established law test. That's the problem. Objective, clearly established law, like it's already got to be in place. So Harlow versus Fitzgerald in 1982 transformed qualified immunity into an objective test based on whether the law was already clearly established at the time of the violation. The test: would a reasonable officer have known that their conduct violated clearly established law? That's you see how they fucking up right there, because we already know that it doesn't matter if they knew, whether through ignorance or design, bro. Whether through ignorance or design, they must respond in damages. No inquiry into subjective intent. The common law connection, there's none. Clearly eliminates all common law. Clearly, bro. Just eliminated it. It is purely, the clearly established law standard has no analog in common law. It is a purely judge-created test with no historical foundation whatsoever. The impact is that officers receive immunity unless prior case law with nearly identical facts establish the unconstitutionality of the specific conduct. So even if it is clearly shown through evidence that it's wrong, if there ain't something that says it's wrong before, it doesn't count. So, I mean, that makes no sense, because if something's wrong and it's never been proven before or shown before, wouldn't this new one then bring forth something for all others with similar identifiable facts and evidence? It's like a loop that never can end, all working in favor of the violator. The critical departure from any common law foundation. Harlow represents a second level of judicial activism. So now we got layers of judicial activism here. While Pearson at least claimed to preserve common law defense, however dubiously, Harlow created an entirely new standard. Oh my God, Cameron. An entirely new standard that had never... Uh-oh. I did it again. It's right here. I'm going to scroll down. Okay. That never existed at common law. The clearly established law requirement is a pure judicial invention. It's an invention with no historical precedent. This makes qualified immunity's claim foundation in common law even more tenuous. The doctrine as it exists today bears no resemblance to any defense that existed when Congress enacted the Section 1983 in 1871. It's a big deal, y'all. This is huge. Huge. Oh, God. Okay. Professor Alexander Reinhardt's groundbreaking research. So the scholar in discovery. In 2023, is this the right one? Yeah, okay. Professor Alexander Reinhardt of Benjamin N. Cardozo School of Law published a groundbreaking article in the California Law Review titled Qualified Immunity's Flawed Foundation. I just want to say I appreciate you, Alexander Reinhardt. If you end up seeing this video, bro, hey, shout out to you, bro. We appreciate you for real, for real. Do your thug dizzle. Hopefully I can be as good as you one day. Unlike previous scholars who relied on the codified version of Section 1983 in the United States Code, Professor Reinhardt undertook meticulous historical research examining the original Enrolled Bill of the Civil Rights Act of 1871 preserved in the National Archives. What he discovered would fundamentally undermine the entire edifice of qualified immunity that the Supreme Court had construed over more than half a century. This was not merely an academic exercise. Professor Reinhardt's research revealed a catastrophic error that had persisted for 150 years, an error that affected every single qualified immunities case ever decided by any court in the United States. Professor Reinhardt discovered that the original statute enacted by Congress in 1871 contained a critical sentence that had been omitted from all subsequent codifications. Any law, statute, ordinance, regulation, custom, or usage of the state to the contrary, notwithstanding. This notwithstanding clause explicitly displaced all state law defenses, including common law immunities. Congress did not leave the question of immunities to judicial interference through canons of construction. Congress directly addressed and rejected state law defenses. The implications are devastating for qualified immunity. Every case applying the doctrine has been based on a corrupted version of the statute that is missing the text Congress actually enacted. It's horrible. It's a very devastating thing for a lot of people for a very long time. And when those who get education of this come back and reapply based on fraud upon the courts or fraud perpetuated by the courts, man, think about how big their claim's actually going to be. It gets very big for a lot of people, bro. And I just hope the people that were denied based on qualified immunity and clearly established law will end up coming to find this information so that they can proceed again, because this is huge. As Judge John Willett of the Fifth Circuit would later write, this discovery is game-changing. Oh, I love it. Oh, I love it. Oh, we're winning. We're winning. The notwithstanding clause, text, and meaning. Quote, that any person who, under color of law, statute, ordinance, regulation, custom, or usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to be deprived of any rights, privileges, or immunities secured by the Constitution of the United States shall, any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary, notwithstanding. You see how that little bitty piece was taken out? That little bitty piece? This is, again, the Civil Rights Act of 1871, Section 1, the original enacted text. The meaning, the legal meaning of notwithstanding. Let's get into it a little bit deeper now. The term notwithstanding is the strongest override language available in statutory drafting. I told y'all, highest of legalese. It means despite, in spite of, and without being prevented by. When Congress includes a notwithstanding clause, it is giving an explicit instruction that the federal statute applies even if state law says otherwise. The notwithstanding clause is a direct command to disregard conflicting state law. In modern statutory interpretation, notwithstanding clauses are recognized as supersession provisions that explicitly displace other legal rules that might otherwise apply. It's very strong. It's very high on the totem pole. All right. The Supreme Court has repeatedly held that notwithstanding clause creates an express command that the statute applies regardless of other legal provisions. What the clause displaced. The notwithstanding clause explicitly displaced any such law, statute, ordinance, regulation, custom, or usage of the state. This comprehensive language covers all forms of state law. General state legal principles, including common law, statute, legislatively enacted state statutes, custom or usage, established state practices and traditions, and common law immunity defenses fall squarely within the law, custom, or usage of the state. Congress explicitly commanded that federal liability would apply notwithstanding any state immunities. So, the statute was not silent on the question of immunities. Congress directly addressed this issue and resolved it. State law defenses, including any fucking immunity that you want to bring onto the damn table, does not apply. Does everybody here get that?
It never should have existed.
Anthony, are you hearing this? Anthony,
I'm
do you
trying
hear
to
this?
soak it in, yeah.
Yeah, they ain't got no immunities, homeboy. They ain't got no state law defenses, my G. It's time to start up a civil suit now. Yeah. Why Congress included the notwithstanding clause?
The notwithstanding.
Say that again. Sorry, I started speaking over you.
Read that part just before the notwithstanding.
That's everything before the notwithstanding is already included. You can go read section Title 40, Title 18, Section 242 right now, and you'll see exactly where they took it out. Same language. The problem state complicity in terror. In the aftermath of the Civil War, the Reconstruction Congress faced a catastrophic failure of state governments in the formal Confederacy to protect the constitutional rights of the newly freed swarthy Americans. Jeez. White supremacist terrorism was rampant. The Ku Klux Klan and similar organizations engaged. Lips are dry.
Hey, Cam, I got a hint for you. If you have a hard time saying the word, just don't say it. Just skip over it.
No, I'll figure it out. White supremacist terrorism was rampant. The Ku Klux Klan and similar organizations engaged in systematic violence, murder, assault, arson, intimidation to prevent any swarthy Americans from exercising their constitutional rights to vote, own property, and participate in civic life. State governments were complicit. State courts refused to prosecute Klan members. State law enforcement officers often participated in the violence or turned a blind eye because they part of that shit. And then the state legislatures enacted laws designed to circumvent federal constitution protections for their friends and shit. Congress understood that state legal systems could not be trusted to enforce federal constitutional rights. State law, including common law immunity defenses, would be weaponized to shield violators from accountability. The solution was the explicit federal override. Congress's response was deliberate and unambiguous. The notwithstanding clause explicitly displaced all state law that might interfere with the new federal cause of action. This was not an oversight or accident. Congress directly addressed the question of whether state law defenses would apply. And the answer was a resounding no. The notwithstanding clause reflected Congress's fundamental distrust of the southern state governments and legal systems. Congress assumed that state law would be hostile to federal constitutional protections and would be used to undermine the new federal remedy. So, by including the notwithstanding clause, Congress made clear that federal courts would be the guardians of constitutional rights and that state law immunities would not shield violators from federal liability. You know, they putting their foot down. They like, I'm letting you know right now, bro, y'all better quit playing with us because it's not going to work. You dig what I'm saying? Put this down right here. We should be okay. Mess that one up, huh, Cam? It's all good. Congress explicitly rejected the application of state law defenses because they knew state law would be used to perpetuate the very immunity that Section 1983 was designed to eliminate. Oh, we're not going to get through all this tonight, by the way. I just wanted to let y'all know. I believe there's like 60-something, my exact page number. We got like 60, over 60. So this is, again, an educational series. You'll have to be here maybe for next Wednesday, because I don't know if we're going to do a Saturday workshop again or not. We'll figure it out. Maybe we'll do a vote in Operation Wisdom at Discord. So let's see. We did 17 and then 18. Can I go full screen on this one? Maybe a little bit. Oh no. Right here. So the 1874 revision, how the clause disappeared. Again, the 1871 was the original statute that was enacted by the Congress, and it was the Civil Rights Act of 1871. Again, had the notwithstanding clause explicitly included. The enrolled bill signed by President Grant contained the full text. Any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary is notwithstanding. It don't work. You can't use it. Unauthorized deletion by the reviser when the statute was compiled in 1874, so only 3 years later. When the statute was compiled into the revised statutes of 1874, the notwithstanding clause was omitted. Okay, no explanation was provided. No congressional debate occurred. No amendment was enacted. The critical sentence just simply disappeared, y'all. Pretty weird.
No, they probably did it on purpose so they can have that power.
Yeah, it's very weird that whoever the reviser was had a conversation with somebody to put a little bit of, all right.
A little bit of money in his pockets.
Mm-hmm.
Oh. All politicians do it.
Again, all this reviser was authorized to do was to organize the statutes, make stylistic improvements, correct obvious typographical errors, and eliminate the redundancy and improve the readability of all of the acts in which they were finally compiling and putting into a codification. And what the reviser was not authorized to do: make substantive changes to the law, delete statutory provision, alter the meaning of the enacted statutes, or change the legal effect of congressional enactments. Like, you're not above these dudes. You were hired to help, not to alter. Yeah. The catastrophic consequence: by deleting the notwithstanding clause, the reviser fundamentally altered the state's meanings. I mean, if this dude really knew what he did and how bad he changed history, bro, I'm sure he would have thought otherwise, for real. But maybe that check for his life was a little bit too important. But the morals, man, like that's pretty bad. That karma's bad. Maybe he's haunted. Maybe he's getting a haunted spirit. So the clause that explicitly displaced state law immunities, the very provision that answered the question at the heart of qualified immunity, was removed. This unauthorized deletion exceeded the reviser's limited authority and created a corrupt version of the statute that has been perpetuated for 150 years. So every court interpreting Section 1983 has relied on a text, missing critical language Congress actually enacted. It's the most wildest thing to me. I can't wrap my head around it, bro. And to think that the Supreme Court has never seen anything like this either, or knew about it in any form or fashion, or had did any research, or not one of them was really to stand up to be first a long time ago, is what's going on.
It's good for them.
Well, I mean, I don't know, man. We have seen just recently, within the past 2 weeks, that the Supreme Court has been caught using ChatGPT. So, just saying.
Nice.
There's
nice.
that. There's that. So go search that up. You'll find it. There's plenty of articles on it, I swear. So the fundamental principle: a clerk cannot repeal what Congress has enacted. This is a bedrock principle of the American constitutional law. Only Congress has legislative power under Article 1 of the Constitution. Clerks, revisers, and codifiers have no authority to change the substance of any enacted law. The Supreme Court has long held that the enrolled bill, the official version signed by the President and deposited with the Secretary of State, is conclusive evidence of what Congress enacted. Now, do you see what's happening? If you bring forth a Section 1983 clause, you can attach the 1871 Ku Klux Klan bill and let it be known within any language that you need to, in any kind of opening statements, in whatever section we need to put it in within your lawsuit, that we are applying and enrolling ourselves into the enrolled bill that Congress actually enacted, and that any qualified immunities claims cannot stand and will not be able to be substantiated for by this court. So don't even bring it forward. Right? That's where we're starting off now. We're already bringing it in, just like our judicial notice. It's coming in.
Quick question: if you've already filed,
can you file an amended?
Well, let's say you're past that. Can you just do a memorandum of law?
Yeah, most definitely, and a declaration, and then attack any kind of response. Yeah, most definitely. Yeah, we can bring it in some form or fashion without no issues. Good question. The Supreme Court has in Marshall Field and Company versus Clark in 1892, the Supreme Court established that the courts must rely on the enrolled bill and not the subsequent compilations or codifications to determine what law Congress actually passed. Again, it's another whole rule act type vibes with me. Hey man, these people keep revising stuff and revising stuff and revising stuff. I'm pulling back to the original intent, whole rule act. But here in 1892, must rely on the enrolled bill. Okay, so when a conflict exists between an enrolled bill and a later codification, the enrolled bill controls. Got it? The codification is merely evidence of the law. The enrolled bill is the fucking law. Tough. Let's hear that one more time. The codification is merely the evidence of the law, but the enrolled bill is the law. Wow. Talk to me nice.
The enrolled bill is what goes out of the legislature?
No, incorrect. Somebody correct him.
That's a question. I wasn't stating.
No.
Find it. Definition.
Oh, you talking about from what Congress passed? Yes. Sorry. Excuse me. Oh, I had it confused. My bad. I was like, whoa.
Help me out.
No, you're right. You're right.
It was a question.
Oh, yes, he's correct. All right. But not any later like codifications from it itself. It's like if you look at if you try and remember the New Hampshire bill and how like everybody had voted on it and it had it within it that you're going to rename all of these statutes and redo the definitions of everything. It's like the bill is whether it's the law, but then they have all of the statutes over here that are interpreting the law. Now, do you get what I'm saying?
Mm-hmm.
The bill is the law. The act.
Yep.
Okay.
Right. The bill was passed with the
truest form of law itself. That's why it says the codification is merely the evidence of the law. Then shit.
Right. The bill was passed with the notwithstanding, and then some bozo took it out.
Yes, but I think now where we're getting a miscommunication is what I'm speaking of is look at it like this. Okay, let's back out of this real quick, and we'll go to the New Hampshire. Okay.
No, I think
this bill, okay, this bill, if it passed, means that this is the law. Okay, this would be the law. Now they're going to go and take this law and they're going to put it into statutes or codification. The codification is enactment of or evidence of the law, which is this. Okay, so think of it like this from now on. Okay, if you're looking at a charge from a statute that's been applied, find the bill that created that statute. Because the bill is the law, not the codification evidence. Do you hear me? Do you hear me? I'm hoping you're feeling the depths of this, okay?
Loud and clear.
Repeat one more time, though.
Statute against you, my nigga, okay? That is evidence of the law. The statute is evidence of the law. But what is the law? Somebody tell me.
The Constitution.
Okay, true. But what else?
Doctrine.
The bill and the act which actually gave force to the creation of the statute. It's getting deep. Now think about that a statute's being brought against you and you go look at that fucking bill. And there's things that are not included from the bill in the statute. Fuck. If this is happening to something this big, you thinking it ain't happening on the state level? Come on now, man. They've been playing us for years. They got us blinded.
Article 6, Clause 2 says all laws are made to be in pursuant. If they're not in pursuant of the Constitution, they are not law.
Which I'm sure a lot of these legislative bills and acts are. The only fact is they didn't include all of those exemptions and everything in the statutes. Now do they, Doug?
Nope. They don't.
It's getting deep, y'all. Y'all starting to see like we can flip this shit on its head for real. For real, for real.
Wouldn't it make it void for vagueness?
It can. Yes, it can. It can. Because again, they're not giving you all of the information. It would most definitely be a due process violation as well. You see, I'm getting tingles, my nigga. I'm getting like goosebumps because I know how deep this can be applied. Like when I see, or when I see it, I can see how it can be applied and argued in such an articulate way that it cannot be denied. And I can, even if like a lower court was to fail to understand the depths of it, how I could just take it up to a higher court to possibly get the intellectual reasoning in which I am searching for. You dig what I'm talking about? Sometimes you just got to get to somebody that's able to interpret and understand the intellectualism in which you are bringing forth in such advanced legalese manners. I'm sorry, sometimes it gets deep, but I'm a creation of the creator, bro, and I'm going to stand on mine. You dig? What's up, little Jasmine? What's up, homeboy? You just had a birthday recently, huh? Oh, you disappearing now. All right, get up out of here then. So the legal implications of the unauthorized deletion. The fundamental principle, quote, a clerk cannot repeal what Congress has enacted, unquote. This is a bedrock principle of American constitutional law. Only Congress has legislative power under Article 1 of the Constitution. Clerks, revisers, and codifiers have no authority to change the substance of enacted law. The Supreme Court has long held that the enrolled... Oh, wait, I already read this one. Did I?
No. Yeah, go back to Article 1.
Okay. In the enrolled bill, the official version signed by the president and deposited with the Secretary of State. You know what's so funny too? Is you could probably hit up the Secretary of State, ask a question, and get a really good solid answer back if you pose the question correctly. See, like my boy Russell Hess, he's been doing that. He's been reaching out to the Secretary of State, and they're giving him answers back, which is helping him for his case. And he's been sending letters back and forth now to get conclusive evidence. It's conclusive evidence of what Congress enacted. I did read this one, didn't I? Or it's just bringing it back in. The Marshall Field and Company versus Clark. In 1892, the Supreme Court established that courts must rely on the enrolled bill, not on the subsequent complications or codifications, to determine what law Congress actually passed. When a conflict exists between the enrolled bill and later codification, the enrolled bill controls. The codification is merely... I did read this, so what happened? How'd I go back? What was we on? This one? Okay. It's not. I did. Oh man, I messed up somewhere. Okay,
you went back for Bob or something.
Man, I messed up.
Double slide.
Okay, I messed up somewhere. It's okay. So the contemporary legislative history. The contemporary legislative history confirms intent. The notwithstanding clause was not an isolated provision. Congressional debates and the Act's structure demonstrate that Congress systematically intended to override state law that might shield constitutional violators from accountability. So the congressional debates, explicit intent. During floor debates, legislatures explicitly expressed distrust of southern states' courts and state law enforcement. Check this out. Listen to this quote from back then. Quote, the state courts are in many localities under the control of those who are wholly inimical to the impartial administration of law and equity, unquote. Representative Samuel Shellabarger, a Republican of Ohio. So Congress recognized that state law immunities were part of the problem. They shielded Klan members and sympathetic officials from accountability for terrorizing swarthy Americans. I just want to say I'm going to stop. Removal jurisdiction provisions. Section 3 of the Act allowed defendants to remove cases from state to federal court when they could not obtain justice in state courts, a direct expression of distrust in the state judicial systems. This provision would be unnecessary if Congress intended state law defenses to apply in federal court, clearly. So the federal habeas corpus expansion. Section 2 of the Act expanded federal habeas corpus jurisdiction to allow federal courts to review state custody when state courts failed to protect constitutional rights. You hear that? You hear that? You hear that?
Yep.
Uh-huh.
Yep.
Uh-huh. Uh-huh.
Yep.
My homegirl told my Sarah, I'm going to get arrested. No, you're not. If you already got a habeas corpus, going to be already ready for you, dig? We ready for you, girl. This provision reflected Congress's determination to bypass state legal systems entirely when they proved hostile to federal rights, and then criminal penalties for state officials. Section 2 also created federal criminal penalties for state officials who deprive persons of constitutional rights. Another provision demonstrating that Congress did not trust state law to hold officials accountable. If state law immunities applied, these criminal provisions would be largely ineffective. The notwithstanding clause was part of a systematic congressional effort to prevent
we the people.
Oh, my boy Russell coming in. To prevent state law, including state law immunities, from undermining federal protection of constitutional rights. The legislative history confirms what the text already says. Congress intended to displace state law's defenses entirely. Entirely. You don't get no defenses, bro. You fuck up, you pay. You do it through ignorance or design. It don't matter. You must pay and respond. Sorry. I know there's a bunch of y'all out there that...
Yeah. Senator says they don't have, public officials have no right to self-defense because they
work for the system.
Commit perjury by their oath.
We ain't there yet.
Yeah.
We ain't there yet.
No.
It's all good. The derogation canon becomes irrelevant. It sure does. A derogation canon becomes irrelevant in application on how they are utilizing it in the Supreme Court. So this is what I'm saying. Like, even if the Supreme Court was to bring forth a hearing, or let's say the defense, because of course we're plaintiffs, right? We're bringing forth the fucking suit. But if the defense was to bring something forth, we're gonna kill it. It's easily. We can easily see the lineup. I gotta take a quick piss. You can easily see the lineup. Doug or somebody, can y'all talk for? I don't want no dead silence.
Okay, no dead silence. I got you right here.
Well, I got a question then. Keep it. So, so you have to be a non-resident, right, to not have to have a driver's license. Obviously, how do y'all deal with like having a bank account as being a non-resident and all that?
PO box. Ask a church to have them as your mailing address, like I did. But that's all like legalese fiction, so
But
whatever.
I don't know. How do you? I mean, if I'm a non-resident, how do you have a bank account and all that? Don't you have to be a resident?
No,
you don't.
All right.
No,
we back to it. We're not talking about like bank accounts and all that tonight. I was hoping that someone would bring
Sorry.
Yeah, it's okay. It's just like way off topic, bro. Like,
I'm gonna read the man jurisprudence, but he asked a question.
yeah. Okay. So again, the derogation canon becomes irrelevant. 1 second.
so if the statute don't state the entirety of the rule which is applying, it's void for vagueness, right?
That's what I'm thinking.
Void
Most
for vagueness
definitely.
doctrine?
If they're not bringing in everything that's supposed to, again, right? The bill or the act is the law, right, Chris? Right?
Yeah. Yep.
Okay.
Yep.
Right. And so when they bring in the statutes from the bill, if those statutes are not giving all exemptions and all entitlements and all immunities and everything else, and making it very distinctively clear, then yes, it would be void for vagueness. Why? Because the interpretation from the notice that they're giving through the statutes cannot be properly applied, correct or incorrect. Because what it would do is it would cause one who is applying that statute in a criminal form or fashion to apply it incorrectly if it's not all put in. Correct or incorrect?
Correct.
Yeah, that sounds right.
Hey, man. There it is for you. All right. So the derogation canon becomes irrelevant. The fundamental principle of statutory interpretation. The canons of construction are gap-filling tools when used when statutory text is silent, okay, ambiguous, you see it, Chris, or unclear. They are not tools for overriding explicit statutory text. When Congress directly addressed an issue, canons become irrelevant. When canons apply, statutory silence. When a statute is silent on an issue, courts may use canons to infer intent. Ambiguity. When language is unclear or has multiple readings, canons resolve ambiguity. And a lot of these canons are what? Ruled in favor of who?
No.
Yes, in regards to us. Why? Because if there's so many different motherfucking meanings that could possibly be interpreted, how can you then say we're going to punish you for being able to come to multiple conclusions of what you've read? It was our responsibility to make it fucking clear in the first place. Hear it, Chris?
Latches. Latches incurred.
Got him. All right. So, and gaps in text. So if Congress left interactions with other law unaddressed, canons may fill the gap. Example, a new cause of action that says nothing about defenses may invite canons. When canons do not apply, the explicit statutory text. When Congress addressed the issue in clear text, canons are unnecessary. Direct congressional command. If the state dictates how it interacts with other law, courts must follow it. Notwithstanding clause. Notwithstanding language resolves conflicts with other rules. Example, a statute that applies, notwithstanding any other law, cannot be narrowed by canons. Implication for Pearson versus Ray. Pearson assumed Section 1983 was silent on immunities and invoked the derogation canon, but the statute included a notwithstanding clause displacing state law defenses. So because Congress spoke directly, using canons was inappropriate. Don't work. Sorry. Move on. Comparison to other Reconstruction statutes. The notwithstanding clause in Section 1983 was not unique. It was part of a systematic pattern in Reconstruction-era civil rights legislation, demonstrating Congress' deliberate and consistent effort to prevent state law from undermining federal constitutional protections. In 1866, the Civil Rights Act of 1866, its purpose was to guarantee citizenship and equal rights to formerly enslaved persons, including rights to contract, sue, and to own property. Quote, any law, statute, ordinance, regulation, or custom to the contrary notwithstanding, this statute explicitly displaced state laws and customs that denied equal rights using identical override language. 1870, the Enforcement Act of 1870. Enforced the 15th Amendment's guarantee of voting rights regardless of race, protecting against state interference. Again, the notwithstanding clause. Oh shit. Congress again used explicit override language to ensure state law could not prevent federal enforcement of voting rights. Then we come across to the 1871 Ku Klux Klan Act, which is our Section 1983 claims. It created federal remedy for constitutional violators by state actors combating Klan terrorism and state complicity. Again, with the notwithstanding clause, the most comprehensive override language explicitly displacing all forms of state law immunities. And then in 1875 with the Civil Rights Act of 1875, which prohibited racial discrimination in public accommodations, transportation, and jury service. Again, quote, any law or custom of any state to the contrary notwithstanding. Even in regulating private conduct. Even in regulating private conduct. Okay? Congress used notwithstanding language to override state law obstacles. Hope you're seeing this shit for real. The clearly established law standard, though. Okay. The standard from Harlow versus Fitzgerald. Government officials are entitled to qualified immunity unless their conduct violated clearly established statutory or constitutional rights of which a reasonable person would have known. What this means in practice is it is not enough that the officer's conduct was unconstitutional. The plaintiff must show that a prior case law established that the specific conduct in the specific circumstance was unconstitutional. General constitutional principles are insufficient. That's crazy. The Supreme Court has held that the law must be clearly established in particularized sense, meaning that there must be a prior case with nearly identical facts. The courts require factual specificity that goes far beyond whether a reasonable officer would have known that their conduct violated the Constitution. Instead, courts ask, was there a prior case involving this specific action in specific context under these specific circumstances? As the Supreme Court stated in Ashcroft versus Al-Kid in 2011, officials can receive immunity unless every reasonable official would have understood that what he did violated the law. That is an extraordinarily high bar. Very. They get to be down here with this preponderance, right? All we have to have is a preponderance. We don't have to have probable all the way without a reasonable doubt. But then when someone does something to us, we have to go to this high ass bar. Like, y'all come on with it, man. We the people. What y'all talking about?
Masters of government.
Trivial distinctions defeat claims. Courts have granted immunity based on legally irrelevant factual differences between the plaintiff's case and prior precedent. Different weapon. Prior case involved taser. Current case involves baton. Immunity granted. Different time. Prior case was daytime. Current case was nighttime. Immunity granted. Like what? Different location. Prior case was urban. Current case was rural. Immunity granted. I can hear him sounding just like that too. Immunity granted. Looking ass. These distinctions have nothing to do of whether a reasonable officer would have known that their conduct was unconstitutional. They are factual minutia that courts use to distinguish prior cases and grant immunity. It's insane. The impossible standard. The clearly established law standard has become nearly impossible to satisfy. Unless there is a prior case with virtually identical facts, courts grant immunity, even when the constitutional violation is obvious. It's almost like if Hood Rivers my judge, ended up granting qualified immunity, and I bring this in, like, can I go after the judge too? Right? Because it's through ignorance or design, right? Whether you knew or you did it intentionally. It's not my fault. Like, you're supposed to be official that's supposed to know your duty and role. And I don't want to be like that, but I'm just saying, you got a duty to know mines. And if you don't know mines like I know mines and you violate mines, hey, we got an issue here. So the feedback loop problem, here it goes. That's what I was talking about. Qualified immunity creates a logical impossibility. A catch-22 where the law can never become clearly established because courts grant immunity without deciding whether the conduct was constitutional or not. You see what I'm saying? Preventing the creation of precedent that would clarify the law for future applicants of getting remedy from their violations. Step 1. Plaintiff sues for constitutional violation. A person whose constitutional rights were violated files a Section 1983 lawsuit against the government official responsible. Step 2. Then court asks, is the law clearly established? Rather than decide constitutionality, the courts ask whether prior cases with nearly identical facts clearly established it. Step 3. No prior case with identical facts. Because the clearly established standard requires factual specificity, there is often no prior case with sufficiency similar facts. Step 4. Courts grant immunity without deciding constitutional question. Damn! They don't even get to the constitutional question. So the courts grant qualified immunity and dismisses the case without deciding whether the conduct violated the Constitution. Step 5. No precedent created. Because the court did not decide the constitutional question, no precedent is created that would clearly establish the law for future cases. Step 6. Law remains unclear. You return to step 1. And the law remains unclear for the next plaintiff. The cycle repeats indefinitely. The law can never become clearly established. You got it? Do you see where we're at here? It's fucked up, bruh.
The vicious circle.
So the logical impossibility. This creates a one-way ratchet. Justice Sotomayor's term. Plaintiffs lose because the law is not clearly established, but the law can never become clearly established because the courts grant immunity without deciding constitutional questions. Qualified immunity becomes a defense that operates as an absolute bar to relief, not because the conduct was unconstitutional, but because no prior court had addressed sufficiently similar facts. It's sad for all my people out there that has failed, and not failed, but were failed. Excuse me. Because those who were subjected to the qualified immunity being approved or granted were deprived of what's rightfully theirs. And I just hope that, man, my hope and desire is, I almost want to put something out there in a reach. I wish I had, the resources to do that, to help people redo this and to say, hey, look, you actually got action again on your cases. Like, let's try this one more time, and let's do it yourself this time. Like, that is so powerful, bro, for people. Like, the empowerment there would just be so fascinating for Operation Wise Dome to lead the way on something like that. Like, game changing. I mean, if we the best on the planet, we might have to do that. Case study: officers who stole during a search. This is the one I was talking about. So Jessup versus City of Fresno. This is in 2019 in the Ninth Circuit. Okay. So the facts, what the officers did. Now, the police officers, what they ended up doing is they executed a valid search warrant at the home of Michael Jessup and Britton Ashgian, who were suspected of illegal gambling, right? Illegal gambling. They out with their friends, doing what the fuck they want as far as gambling. And, if here comes the cops. You can't do that. Like, nigga, chill.
Fuck, I can't.
For real, though. The officers did not include the seized money and coins in their inventory report. Go figure. The property simply disappeared. The plaintiffs alleged that the officers stole the money and coins during the execution of the search warrant. This was not a case of disputed facts or mistaken identity. The plaintiffs alleged deliberate theft by law enforcement officers during the execution of a warrant. The Ninth Circuit's reasoning now. Okay, listen to this. The Ninth Circuit granted qualified immunity to the officers, holding that the plaintiffs had not identified a prior case clearly establishing that theft during the execution of a search warrant violates the Fourth Amendment. How fucking dumb is that?
What the?
The absurdity is that the Ninth Circuit essentially held that the officers did not have a fair warning that stealing $175,000 during a search would violate someone's rights or violate the Fourth Amendment's prohibition on unreasonable searches and seizures. Like, get the fuck out of here, bro. Y'all talking about
not alone the thou shalt not steal laws of nature.
That's what I'm saying. Like, what even happened? I don't see how the lawyer lose on that, bro. Like, I don't even, like, that's crazy. For real. So, officers who allegedly stole $175,000 during a search received qualified immunity because no prior case held that the theft during the search violated the Constitution. This is our qualified immunity now in practice, y'all.
That goes against Marbury versus Madison.
I guess we might need to get another petition wrote up in this thing. Case study: trivial factual distinctions. Federal courts routinely grant qualified immunity based on trivial factual distinctions that have no bearing on constitutional reasonableness. These distinctions allow courts to avoid deciding whether conduct was constitutional by finding that prior cases involved slightly different circumstances. Weapon used, violation. Officer used excessive force causing serious injury. Distinction. Prior case involved taser. Current case involved baton. Immunity granted. Time of day, right? We went through a lot of these. One we didn't, though, victim position. Officer shot unarmed person. Distinction. Prior case was standing. Current victim was sitting in car. Immunity granted. Duration of force. Violation. Prolonged use of force after compliance. Distinction. Prior case involved 15 seconds. Current case, 20 seconds. Specific action. Violation. Canine attack on surrendering suspect. Distinction. Prior case, victim was lying down. Current victim was kneeling. Immunity granted. Number of shots. Officer shot fleeing unarmed suspect. Violation. Distinction. Prior case involved 2 shots. Current case involved 3. Type of restraint. Violation. Positional I hate this word. How do I say it? Come on, somebody knows this.
Asphyxia.
Yeah.
Asphyxia.
No, I don't think I don't even say it like that.
Asphyxiation.
Yeah.
Asphyxia.
During restraint.
Choking. Choking.
Someone needs to mute up, please. Anthony, yeah, there you go, boy. Distinction. Prior case used knee on back. Current case, knee on neck. Immunity granted. The pattern of absurdity, right, is that these distinctions have nothing to do with whether a reasonable officer would have known that their conduct violated the Constitution. They are factual minutia, unrelated to constitutional analysis. This transforms qualified immunity from a shield of reasonable mistakes into a blanket of protection for obviously unconstitutional conduct across our nation, as long as the specific factual scenario hasn't been litigated before. And it will never be litigated as long as these people never accept and bring them into deliberation. And that's the problem that we're facing, bro. The perverse incentive structure. So the qualified immunity creates backward incentives, actually. The more novel the violation, the likelier the immunity, exactly the opposite of rational system. The normal legal system under conventional violations is a result, liability and accountability. The novel/creative violations is the result is liability and accountability, okay? And then the incentive created, don't violate fucking rights, conventional or novel. You're going to be fucking accountable. You're going to be held accountable, bro. Straight up. You will respond in damages. The qualified immunity system, though, is very different because in its conventional violations, the result would be possible liability if law is clearly established, which is rare because they don't accept shit. And then novel creative violations, the result of guaranteed immunity because no prior case with identical facts. Incentive created. If you violate rights, do it in a way, no case, no liability. Do it in a new way, no case, no liability. You think they ain't figured that out and they don't talk about that, bro? Hey, bro, if you want to get away with it, just do it like this because nobody's ever done it. You know, there's no Supreme Court case law on that. Pretty fucked up, right? But I guarantee you there's people out there talking like that. I would never talk like that. But for some reason, other people like to hurt other people. It gets them off. Like, that's what their life is about. Very weird, bro. I will never understand how you could utilize this life to do it, but it's weird. Very, very weird.
That goes against Marbury versus Madison, though. Like, saying there has to be a case for it to be valid? No.
Most def, bro.
Well,
Examples of the... Go ahead, Chris.
Well, they gave themselves immunity, so it's cool for them to do whatever.
Yeah, if it sounds good. But then again, the problem is, I just don't think there's been people that are really trying to challenge it strong enough. I really don't think there's been people that's been trying to really argue it enough. Now, what I do know is that we've got good judges out there, right? Like I said, Judge Carlton Reeves, I may not agree with everything he's saying, you know what I'm saying? But what he did bring forth in his qualified immunity order that, you know, is essentially helping bring this to full fruition, and others now. There's more. He's not the only one now, bro. There's a lot more that's speaking on this. It's out there. Bro, this is getting big. Examples of the perverse incentive in action. Stealing during a search. Immune. No theft case during warrants. Use of weapon. Immune. Prior cases use different tools. New context. Immune. No case in that setting. Combined violations. Immune. No case on that combo. Clearly established right. Possible. Only if facts nearly identical, and invent a new abuse. Immune. You get to do it once. The fundamental perversion, okay, is that a rational system deters misconduct by imposing liability. Qualified immunity does the opposite. It rewards innovation in rights violations and shields the most creative abuses, turning a shield from reasonable mistakes into a playbook for avoiding accountability. Oh, yeah. Yeah. So we're leaving off on 27 today, okay? For part one of our qualified immunity, the death of an illegitimate doctrine. We're cutting it off on slide 27, which equals up to 9. Y'all know who I am with my numbers, bro. And that's where we're leaving off this one. What I wanted to do right now is I wanted to just ask, like, how y'all enjoy that? How does it
Loved it, Cam. I'd love the PDF copy.
Definitely important
Good stuff.
information.
Good stuff.
Did a great job, man.
So y'all are finding this helpful then?
Definitely.
Yeah, this is gonna open the door. Like, not only open the door, you like kick that son of a bitch in.
We got to, bro. We got to, bro. Like this is some serious shit, bro. And some people may need to watch this like a couple times to see the depths of things and utilize some of what I presented today in relation to just their own court cases. Because even if you're not fighting qualified immunity, it's still going to be applicable, right? Because now we're starting to see that you can utilize going directly to the bill, which gave some substance to the statute, to see where there's inconsistencies, like Chris was saying, right? If you're going to find those inconsistencies, man, it is very easy to hit for ambiguity and void for vagueness. Jasmine loves that too. And I'm sure Jasmine's going to find a bunch. If she looks, I guarantee you she's going to find it. She knows how to find that shit. She don't play. So when it comes
constitutional challenge right off the bat.
Say that one more time.
Wouldn't the constitutional challenge be right off the bat be the first move then?
I think just an invocation. In what form? Give me more context.
Challenge the constitutionality of the statute.
Yes, but like what type of case though? Like where you
right
okay, but what kind of case? What we doing? Where we at?
So, say driving off suspended. What is it? Something like that. Driving off suspended, no registration, no license, no insurance. Okay. Constitutional challenge, the statute, the statute they're using is unconstitutional.
Well, yeah, for sure. But what I'm saying is are we going to look at the bill in which gave substance to the statute? Right? Yeah, the statute is evidence of the law. And what is the law, Chris? The bill or act. Now, these legislators clearly. So what I'm saying, even if anything that they're applying is unconstitutional, you can still bring it forth, of course. What other questions y'all got?
Wouldn't that turn into something that became overly broad or ambiguous that could be raised?
Yes.
That's the deal with it. Yeah. Hey, this is ambiguous because the actual intent is this. Right.
Yeah. It causes due process errors too, because was you properly noticed of everything that is entitled to you? And then you got another aspect that you bring into.
Why
what do I mean by that?
Well, I mean, why due process?
Okay. Well, are you okay? Somebody else tell them. Come on, Jasmine. I know you know what I'm talking
about. I'm literally talking. What was the question?
Never mind. Don't worry about
it. I'm sure it makes due process errors. Because
somebody else can say it. How?
Because all information has to be there for consideration.
Okay, you hear him? Your mic's fucked up, Antonio. Your mic is muted like a motherfucker, bro.
Oh, is it? Oh, sorry. I'm on the earbud.
Okay, bring it up to your mouth.
All information has to be present for.
Bring the mic closer to your mouth.
Okay. It said all information has to be present for there to be consideration.
Correct. If you're not getting a fair notice of what is right and wrong, you see what I'm saying? Clearly. Is that not a violation of your due process rights?
Absolutely.
Okay, then.
Well, let me. I want to play
Sixth Amendment and Fourth Amendment.
Yeah. Wait. Oh, y'all are conflicting. Try again.
You go ahead.
Oh, I was gonna say. When I was doing some reading, they basically the case law stated that although traffic tickets, will only cite language that follows the statute and list the statute that you violated, it was meant to have like a reason. It was meant to, kind of be informal to put less pressure on the officers. Now, but that does not it basically doesn't relieve the court of having to do their duty to still inform you of the nature and cause of the action if asked. So if you are in court and you say, hey, I don't understand the ticket. I need a better explanation. They have a duty to then give you more information on the nature and cause of the action.
Thank you.
If you read the ticket, because basically they put you on quote unquote notice because you have the ticket, you have the most of the time you have the statute that they're claiming that you violated, and they're basically putting the duty on you to do your due diligence and read the statute that they've cited on the ticket. So when you go in there and you say, yes, I understand the nature and cause of the action, they're basically like, oh, okay, so you read it, you're cool, you got it.
Yeah. So you understand the charges that you've been charged. Do you understand the? Yeah. No,
Yeah,
I really don't.
and
No, I don't.
there's no vagueness in the idea that river is a road.
That's overly broad.
Oh shit! No, it's not. Bob. I've been working on yours. Bob, I want you to know I've been working on yours, bro. A lot of yours is already formulated. I've been dragging it in today, but there's some things I gotta fix. So I think tomorrow we'll have it all lined. I'll have it all lined up for you, Papa. Okay. Just wanted to let you know I've been working on you.
I was just saying, since 2019, the guy comes out and says, "No problem," and then 6 years later, they're all up my
ass. They want them dollars, man. Them fiats.
I don't mind the dollars. It's just the the vagueness and the pursuit of happiness that they're destroying on me.
Yeah.
All right.
Okay, when I read Article 1, Section 1 of the Constitution says all legislative powers are invested in the one Congress. That means Congress in Washington, D.C. So states have no constitutional authority to make law whatsoever. Of
course they do.
They can only make public policy. Who does public policy apply to?
No, 10th Amendment, that which was not...
Their 10th Amendment talk about...
It does. That which was not specifically given to them or nor denied it to the states, meaning this Constitution didn't deny it to the states, is the property of the states or, quote, comma, or the people. So they actually totally can, as long as it doesn't conflict with the Constitution. That's the whole, it just can't conflict with the Constitution.
All state law must be in pursuant.
Pursuant, yep.
Pursuant, yep. For sure.
So that's why the states are not fully sovereign; they're quasi-sovereign.
Most damn. Now, what I will say is, we're ending it off on this is part 1 of our qualified immunity and the illegitimate doctrine as it has been applied to us. A lot of this is unconstitutional. I hope y'all are really recognizing how important this is. This is a really big topic, man, and a lot of people really need to get their hands on this information, and stand on it, because there's thousands of people right now who are getting hit with qualified immunity claims. And I don't know if their attorneys or these pro se litigants are actually utilizing the new information. And utilizing this, you shut down any qualified immunity claim. You get none. It's clearly, that's how it works. This clearly established law, doctrine that they've been applying, is not applicable. It does not exist. It is a farce. It is a fallacy. It is an illusion. It is not real. Okay? So I hope tonight's part 1 course, again, on qualified immunity has been helpful at least. We're going to be getting deeper. Again, we got about 67, 69 slides to go through. So this is into part 1. I just want y'all to remember, I am you and we are us, and we are all a part of this great I am. If you want to become a member of Operation Wise Dome, you can do so on PIITP.com. And we would love to see you in the Discord and join us. We have so much fun, bro. Like, we get dismissals all the time. It's lit. We got a lot of civil cases moving too. So it's shaking and baking. Now, if everybody here, all of my Wise Domians, y'all want to unmute and say bye to YouTube, that'd be like...
Notwithstanding.
Bye,
YouTube. Bye, YouTube.
Rewind and play again. YouTube.
And repeat.
Bye, Cam's merch.